morning, everybody. Thanks for coming out. A couple housekeeping things. This will be our third AGC Legal Series presentation. If there are any topics that you want covered in the future, we're here for you. So let us know what those are. We'll put one together. Plan is to go monthly. So again, if you have anything, email me or anybody else here. And we'll make sure to present on that. All of these presentations are available online on our website. So this one will be up sometime in the next week or so. The previous ones are already up there. Our topics would be employee performance and discipline, and then key contract terms to look for when you get one of those contracts that comes over, and it's 40 pages of small print. You don't want to read it. This will kind of give you a little bit of an idea of what to be looking for. If you have any questions, particularly the online people, just go ahead, unmute yourself, start talking. We can hear you in the room. The presenters are certainly fine with that. So if anything comes up as it's being presented, feel free to pipe in. As for the topic specifically, withdrawal liability for signatory contractors, candidly, it's one in my litigation background before I got here, I didn't know a whole lot about, but the little bit I do know is, by analogy, it kind of looks to me like child support and maintenance for signatory contractors, both in sort of the way it works and the emotions that people that might potentially have to pay it have when they look at it, especially when they see the amount. So with that, I'll turn it over to two people that actually know what they're talking about. Bill Tovin and John Mossbert. They serve as fund counsel on a number of funds, work with this in a professional capacity sort of all day, every day. So they're from the Reinhart firm over in Milwaukee. So with that, I will turn it over to them.
Thanks. Thank you very much. And I guess as a starting matter, can the people remote hear us okay? Since nobody said anything, I assume that's yes. Or not, or didn't hear us.
If people can pipe in, if you can't hear us, there's a sort of a large microphone hanging from the ceiling, so we'll adjust our tone if needed so that you can hear us better.
And again, this should be ideally a conversation. It's a pretty technical area, but as we go through it, I think there's some key concepts that we can kind of boil down, distill, that when you leave today, you don't have to understand all the actuarial science that goes into withdrawal liability, but some of the key tripwires and things to be aware of. We really want to emphasize those, but if anything is specific to what you're dealing with, or you have questions based on what we're presenting, by all means interrupt us, because Bill and I were pension attorneys, health plan attorneys. We're used to going to meetings, always very interactive with the trustees. If we're doing our job right, we're not giving a monologue, but it's a back and forth because we want to make sure everybody's moving forward with us. And although we are pension attorneys, we have done a little bit of work with employers also. Reinhart's a benefits firm, but we also have some employers we work with. I've worked with employers over the years, so I've been on both sides. I think the perspective we'll have is, which should be of interest, is what the funds are looking at.
And just so, and we work with over 100 funds around the country, defined benefit, defined contribution, health. So we are fortunate enough to have a large group that works in this area. We see a lot of different scenarios that impact employers and funds. And so fortunately or unfortunately have a lot of experience dealing with withdrawal liability. While there's always new scenarios or new issues that can come up, we, again, fortunately or unfortunately, see a lot and can address most issues. All right, John is going to take, so I'm Bill Tovin, this is John Mossbert. John's going to take the lead, and I'll be the sort of comedic relief as best I can.
Setting yourself up. All right, so some of the key themes we're going to talk about: withdrawal liability. How many of you have received estimates for what your companies would owe if you were to withdraw from a plan? So at the estimate stage, it's a really big dollar amount. There's some sticker shock and awe aspect to it. But with that in mind, I think one of the things you want to get through is if you understand some of the specifics, it's predictable, it's manageable. It's not going to, it shouldn't be a surprise event when it pops up. And there's some things you can do to plan for it. So we want to look at some of what the specific triggers are. You're not going to experience a withdrawal unless you do something. There are complete withdrawals where you completely exit the plan, and then there are partial withdrawals kind of leaking out where your contribution obligation isn't as robust as it used to be because of some events, and that can trigger a withdrawal assessment as well. So it's a complicated area. It gets more complicated because there's a general rule that we'll talk about, And then you throw out the general rule, and there's a specific exception for the building and construction trades, which is a huge exception. It's a very difficult to trigger withdrawal under the building and construction rules. Very easy to trigger a withdrawal under the general rules. So you have to kind of keep that dichotomy in mind. There are a couple different rules going on, and you have to sort out the kind of plan you're in and the kind of employer you are and what you're doing. So this is kind of a prelude as we get into that. I know it's a little mind-bending to say, well, the sun rises in the west, and then except for these rules when it rises in the east. So just kind of keep that in mind as we go through it.
For those employers who, the assumption is that most employers who are interested in this, participating online or here, are going to be primarily interested in the construction industry rules. And that becomes the exception that kind of swallows the rule, as John said. But in fact, we were just speaking, you may have exposure to non-construction industry plans as well. And so it's important to understand the general rule, and then we can also talk through the exception in much more detail. But without understanding the general rule, I don't think you're going to understand the exception as well. You also may inadvertently do something that could trigger a problem if you, for instance, are in central states or one of the non-construction industry funds that are around. So
Right.
We'll get into that.
The definition of employer is probably the broadest definition under law. So if you're used to, well, we're an employer for tax purposes, or we're an employer for these purposes, there's different lanes that you can be in as an employer. These rules, they collapse everything in as one employer. So you may have different divisions. So you have to keep in mind that the definition of employer here is incredibly broad, which is relevant for liability purposes. And also can have the effect of sometimes trapping. You may have a trade or business operation that's not incorporated, and that can get lumped in to the employer definition, which creates exposure. So we also want you to leave today not only knowing what a withdrawal is and where those fault lines are, but also know who the employer is. If there is a blow up, who's the fund going to go after? And I think a lot of accountants and attorneys would be surprised that they've learned what an employer is or the extent of some of the exposure. These rules kind of preempt the playing field and are very broad.
And that can even include, and we'll talk about individuals. If you have a business that you're running that's unincorporated on the side, that's interacting with the other businesses, you can run the risk of having personal liability. We'll talk about that.
On the other hand, we'll give you some comfort. These rules do not allow for piercing the corporate veil. If all your obligations come through corporate entities, all your operations are incorporated, you file the corporate form, there's no boogeyman that will get to the owners other than veil piercing, or if you fail to incorporate one of your operations. And the last thing I want to emphasize too is that, again, that sticker shock, we owe $5 million in withdrawal liability. Well, the reality is you don't have to pay the full withdrawal liability when you withdraw. It's more of a cash flow obligation, and the amount of withdrawal liability is tied more or less to what your contribution obligation was. So it's not a high five event that we've withdrawn and now we've got to pay withdrawal liability equal to our contributions, but the actual withdrawal liability is more of a cash flow issue. So you just have to kind of keep that in mind too, what the impact's going to be on our bottom line. So those are the key themes. So we'll kick it off with some background. I mean, the defined benefit pension plans are plans that provide annuities for the lifetime of participants. So you work throughout your career, your employer contributes to the plan for you, you retire, and then for however long you're alive, the plan's going to be paying the monthly annuity. So that obviously creates some funding challenges. We're funding today for obligations that are going to be paid 40, 50 years from now. So it gets a little complicated.
I mean, if you think about a 20-year-old that you're employing now, they may not start to collect for another 40 years, and between them and a surviving spouse, it could be another 40 years of payments. You're talking 80 years down the road, conceivably, before the true liability goes away. So there's just an incredibly long tail on these plans.
In contrast to the other side of the pension world, the defined contribution plans, profit sharing 401k, where the benefit is just whatever's in the account. The employer makes its contribution, the employer's done. This pension plans, defined benefit plans have a tail that goes on and on. So withdrawal liability was created in 1980. ERISA came around in 1974. And one reason for withdrawal liability is we were starting to get into these multi-employer plans with kind of a last man standing scenario, where employers would leave the plan's assets weren't matching the lifetime promises that were made for benefits. And there was a concern that there'd be a rush for the exit because if it's the last employers in the plan that have to pay everything, they're going to withdraw in advance. So the withdrawal liability rules were intended to address that by allowing plans to go after employers to have them pay their share of the delta between what was required to be funded to pay those lifetime annuities and what was actually in the plan. And if you think about it conceptually, benefits are paid with contributions that come in for hours worked and earnings. If the employer is gone, we're not getting the contributions. So as a proxy for those contributions that were coming in, withdrawal liability fills that gap. And this is to the point I kind of alluded to. Even if you paid all your contributions to a defined benefit plan, the law doesn't care. It's not a defined contribution plan. We're all needing contributions. We need contributions, but if we don't get our earnings target, or if our mortality assumptions aren't what we thought they were, or some other big company goes bankrupt and can't pay, all of a sudden the fact that you paid your contributions isn't enough. Withdrawal liability will seek to keep the plan funded. And the other thing too is there's no intent. There are situations where you can experience a withdrawal where you didn't intend to. A decertification would probably be one example, but another would be just the business model is failing. I see a lot of print trade plans I work with and the industry's changed. Nobody's buying newspapers, or very fewer people are. We had an Atlanta employer that printed the phone book in Atlanta. Well, they went to a disc like 10 years ago. So guess that employer's now out of business. It affected the withdrawal. It didn't want to go in. It didn't want to go non-union. It didn't want to pull the plug on the plan. It's just sometimes things are beyond your control. You're not there to pay contributions anymore, and the fund will look at it as a withdrawal.
I mean, I think, and it's just worth pointing out, because we hear this regularly, is employers will point out, I paid every contribution I was supposed to pay. I wasn't delinquent. We had a collective bargaining agreement. Every contribution that was called for under the collective bargaining agreement, I paid. How can I owe anything more? And this is this additional liability that goes beyond the contributions that are actually being paid to the plan. And it's a very rude shock for employers sometimes when they find out that this liability exists.
So what is withdrawal liability? As we talked about, there's these lifetime promises. So you have to bring an actuary in who will identify how long people are expected to live. They'll project and guess what kind of benefit they're going to take, how many will be married and have the exposure for the spouse. And then they'll take all these 40 or 50 year threads of benefits that potentially be paid and bring it back to present value dollars. And you have assets, so they have to project what those assets are going to earn every year. So there are a lot of projections that go into determining point in time what the value of the plan's liabilities are, and then you compare those liabilities to what your investments are equal to, and to the extent the actual liability exceeds the assets, you have withdrawal liability. I think most plans we work with assume they're going to get 7% return every year. And some years, like last year, 2019, they did better. 2018, most plans were negative 3 or 4% in 2018. So if you assume you're going to get 7, instead you get -3, you didn't lose 3%, you lost 10, because the bogey was 7. And it's, you had 2000 to 2002, the S&P 500 was -3 consecutive years. And then you had 2008 with the global collapse. Those shock events to the investment return, when you expect a nice steady 7% a year, create holes. And if you don't have contributions coming in and earnings coming back, that's how a lot of these plans got in a shortfall situation. The trustees, perfectly prudent how they invested the assets, but when the market, or the whole global market, what happened in 2008, there's nothing much you can do about that. So that's, I think, the biggest source of loss isn't that people are living longer, although that also is putting strain on funding. Mortality has been going up or down, I guess. But the investment returns have been not as predictable and not at the level needed.
But so that's, you do want to sort of, like, if we contributed as we're supposed to, the actuary helped set the contribution rate, they set the accrual rate, we should be okay. But you have those investment losses, or even in years where you've had great investment returns, the actuary comes in and says, people are living longer. We had expected people would live to an average age of 80, and now it's 82. Well, that's 2 more years of payments when I talk about that tail, and that creates additional liability that was unanticipated at the time they set those earlier rates. And all of a sudden you find yourself in a deficit, and you end up with unfunded vested benefits, the UVBs that are described on the slide, and that creates the withdrawal liability for the employers.
For central states too, then another assumption you build in is that we're going to get this level of contributions in the future. Well, then there's changes in the industry, and the level of employer contributions tends to tick down. So there are some things, again, prudent trustees have a basis for predicting, and it turns out, my print trade is another great example. 20 years ago when they set up their funding projections, no one could see that the internet would, in digital, would swamp paper. So.
Well, and even just when work slows down here, you know, when we see the work slows down, they expect it to get X million hours and contributions in any given year. Work slows down, there's no lending, whatever. You know, those economic shocks result in holes that have to try and be filled somehow.
So the key term for withdrawal liability would be unfunded vested benefits, UVBs. We have a lot of acronyms we use, but the unfunded vested benefits very simply are the shortfall between your assets and the present value of the liabilities in any particular year, changes year to year. If you withdraw from the plan, again, we need to make up for those contributions you were going to pay, and withdrawal liability is the proxy for that. So conceptually, I think the law makes some sense. The plan needs to get back to full funding. Employers are leaving. It's a one-shot opportunity to assess and extract something from the withdrawn employer. So as promised, the employer definition here is very broad. We'll start with the statutory definitions. It's called a control group. It's the whole corporate family. So if you have brother, sister companies or other related entities, we'll give some details about those. They're all viewed as one employer. So it's relevant for, let's say you own 5 companies and one of them goes out of business, and that's the company that was in the plan and withdraws. And oftentimes companies are withdrawing because they're not a going concern. They don't have any assets. So the plan knocks on the door and the out of business employer says, we can't pay you. Well, the plan then can turn around and look at other members of the corporate family, and if some of those have assets, they'll go after those entities. It's also relevant if you own a bunch of companies and they're in one plan, you can shut down one company, and that won't be a withdrawal if your other companies are still chugging along in the plan.
And I think so, and while we'll go through these rules in some level of detail, that control group analysis is incredibly complicated. And if you ever need help with that, you're going to, it's not as simple as we're going to present it today. It's a very complicated analysis to figure out exactly who's in the controlled group and who else might share in that liability. So
I would guess that most of your accountants aren't keeping track of control group because there really are no other reasons. I mean, the ACA has some control group aspects to it, but there really is no other. I mean, if a company takes a loan from a bank, the bank is stuck with that company. They can't look at the whole corporate family. Most law is focused just on the corporate entity that's before it, whereas this law aggregates them all. So in the normal course of business, you're not going to be thinking about related entities being one and the same. So it's kind of a mind bender. And to the extent you haven't looked at your control group entities, it's something that even your accountant or your attorney may not be familiar with, and the rules are pretty complicated, as we'll see with this next slide. There's 2 types of control group entities. There's the brother-sister company. This involves a group of 5 or fewer owners who have effective control over a number of companies. And effective control is viewed as, there's a couple percentage tests, the 80% test and the 50% control test. You look at different ownership percentages in companies and then figure out whether or not there's a brother-sister control group. Some are simple examples and some can get pretty attenuated and complex. But that would be one situation. You've got a group of 5 or fewer owners. They own a bunch of companies in combination, different shares and interests in each company. And we have to sort out whether those companies, because of that common ownership group, would be a brother-sister employer, single employer.
And that can get incredibly complicated with, I own a percentage and he owns a percentage, but Derek owns a piece over here and Bob owns a piece over there. It's really, really complicated to do unless it's really straightforward, like I own 100% or something.
Yeah, and the other thing too, often in construction, we see these are family businesses and there are attribution rules. So you may think that, well, my son and my spouse, and we spread it out among different people. Well, sometimes the ownership of a child is imputed to the parent, so there aren't two owners, there's one. Or trust. You set a trust up and you put some of the ownership interest in a trust. Well, we'll look at who the beneficiaries are and see if that group can be combined to create a brother-sister entity. And the second example is the parent subsidiary. We've got a parent corporation that owns 80% or more of the subsidiary, which I think is the next slide. Yep. So again, these are control tests. If you have any interest in digging into them, we have tax people who do this, some backroom people who eye shades and all, because the rules are very complex, especially when ownership gets diluted among families or trust funds.
So in one point, I will say, but while John and I are benefits attorneys and work with these rules on the fund side, the corporate attorneys in our office will routinely sort of come to us to try and fit, because they'll see in transactions when they're helping a buyer or a seller, these types of issues come up where they weren't anticipated, and it can really throw a monkey wrench into whatever the transaction is that they're proposing. And you know, obviously buyers are concerned about it. Sellers may not be aware of it. It can turn what seemed like a good transaction into a bad one pretty fast.
So the other requirement, in addition to having these ownership relationships, is the entity has to be a trade or business, which means its primary purpose is for profit. So I think most of the companies you work with are clearly trades or businesses. Where sometimes people get tripped up is you'll have side businesses. The owner will have something that they do on the side and not really realize that it's a trade or business. So leasing is a good example, and the law kind of goes back and forth. If you're leasing to your company and the company's in a plan, that leasing activity will be a trade or business. But there's a court case where the owner of an employer was leasing apartment space above his garage. And the plan came and said, that's a trade or business. And you didn't incorporate it, this leasing arrangement you have above your garage. So you, individual owner, are individually liable for the company's debts. And the court said, nah, the leasing above the garage doesn't quite become a trade or business. There was a case where a guy retired and kind of had a golf course maintenance business. Maybe it was a hobby, maybe it was a business. The court said it was a trade or business, and because you didn't incorporate this golf course service you did, you were in the soup as an owner. So it's important to kind of sort out, are you doing anything that rises to the level of a sustained trade or business to make money, not a hobby, the guy with the apartment above the garage that he did to keep his wife busy. So it's got to be more sustainable, but I would look at all of your operations, all the things you do, to see if potentially you've set up an inadvertent trade or business that's under common control with the corporate entities that participate in plans.
So sort of the more obvious example on the lease would be, instead of the apartment above the garage, would be actually owning the property and leasing it to the company for its use for storage of equipment and things like that, where you just happen to own it and you have a lease with the company and you're getting paid and you're sort of effectively operating a trade or business. And if you haven't incorporated it, you're at risk.
And that's the next slide. It's a very common scenario. I had a case earlier this year. In 2019, it was a meat shop that went out of business, no assets, but the property that the butcher shop was located on was owned by a trust that the owner of the company had set up. And so we explored going after the owner of the company for having this unincorporated trade or business. This is a very common relationship we see where the corporate entity is leasing the building or the facility from the owner. You've got two different companies as an owner. That leasing relationship with your employer, with your company, could be viewed as a trade or business. And this really gets pretty awful if the trade or business isn't incorporated. So if you are, if you've got a partnership or a sole proprietorship where you're leasing to the company, when there's a withdrawal, that will be identified. And again, the good news here is if everything's incorporated, they can't get at you individually. The downside is that we run into this all the time.
I don't fucking know what to do to deal with this. The power goes out in fucking places.
Was that a specific example?
What did Bill do?
Did I do something? I don't think I did.
It's power goes out.
Oh, all right. If something went wrong and it's technology-based, I assume it's my fault.
Yeah. Don't look to us.
So our corporations are LLCs or LPs and things like that?
Yeah, S Corp, C Corps, LLCs. The LLC is, it's taxed as a partnership, but it has the whole corporate shield protection as long as you maintain the corporate form. Yes.
How far back do they look for these relationships or related businesses? Is it just what's active at withdrawal?
Yes.
Okay, so if it was, we didn't lease anything this year, we leased it last year, that doesn't matter.
It's the trader business is in effect at the time of the withdrawal.
Okay.
So after, we'll have an example under the construction rules where an after acquired entity can be relevant for triggering withdrawal liability. But as far as you take a snapshot of everybody who's in the corporate family, all the trades or businesses on that date of withdrawal, and that's who the plan can look to.
But but don't wait.
Right, I'm just,
Yeah, I know, right, but yes.
because if it's like a bankruptcy, well, I can go back so far and look.
Right. Well, and we'll talk a little bit about a rule that does allow for sort of a retroactive look back at some evade or avoid rules where they'll go back and look to see what some transactions might have been, why they were done in the past to possibly trigger some withdrawal liability rules. So we'll talk about that in a little bit.
I think the last slide we have here is, the definition is growing, and these are some concepts from labor law. The alter ego single employer. So if you don't have enough common ownership to have a control group, it's more diluted. But you really have two different companies that are hand in glove. They're working together. Employees go back and forth. The operations are shared. Customers are the same. That alter ego can be viewed as a single employer. Also, the successor theory, and this blew up in about 2016. There was a big case, the auto mechanics case out of Chicago. The successor theory applies primarily in an asset sale where there's continuity of operations, which in most cases, if you're buying the assets, you're going to continue the operations. So that requirement will be satisfied, and it always has been satisfied. That wasn't the issue. The issue was you also had to have notice. The buyer had to be on notice that the operations it was buying were in a multi-employer underfunded defined benefit pension plan. And for years, plans couldn't prove the buyer had knowledge. Knowledge is a hard thing to prove. But this 2016 case from Chicago, which applies to Wisconsin, Indiana, and Illinois, the judge there said, well, if you knew you were buying the assets from a union business, then you should have known that most union members are in pension plans. And then you should also know that most pension plans are underfunded. So you had knowledge, you had effective knowledge. So after 2016, the successor doctrine that had been pretty narrow has been blown up. And for asset purchasers, I mean, you learn in law school, stock sales, you buy the whole kit and caboodle, you step in the shoes, it's clearly your liability, whatever the seller had. But asset sales, you thought, well, no, I'm not responsible for the debts of the seller. This is an exception to that. So it's something to be aware of. And Bill talked about our corporate attorneys. It's complicated things a little bit. It's pretty clear under the law that if you are an alter ego or a successor, you might be responsible for what the predecessor owned. But I've also used this theory to effect a withdrawal too, and we'll talk about that in an example coming up. So this broadening definition of who an employer is, and also I want to point out that the alter ego and successor doctrines under labor law are related to these, but these are a little bit broader. So again, things to keep in mind is to identifying who's who and might have exposure. Now we've kind of laid the playing field, why there's withdrawal liability, how it's kind of generally calculated, who the players are, and then now we get into what the withdrawals are. And this is again the general rule versus the construction.
When they calculate the liability that you would have to pay for withdrawal, and you have a brother-sister company relationships, if you can cover the liability for that one individual company, they aren't going to bring the liability for the other companies in, are they, at the time, if you want to just get one company out clear?
Are both companies in the plan?
Yes.
So they'll view, if one of the two companies exits and the other one's still in the plan, We'll get into the complete, that's not a complete withdrawal because you're, as an employer, you're still on the plan, then you're looking at whether you've got a partial withdrawal. But from the plan's perspective, you may have 3 different, S corps, each one's different legal entity. From the plan's perspective, it's one. So if one disappears, doesn't really, it's a non-event unless there's a partial. So that, you should be able to point to the other members of the control group. That's actually where the control group helps you. The fact that one of the entities falls off, that looks like a withdrawal. If you have other entities in the plan, it's not a withdrawal. Bill and I work with some national plans where they got grocery stores all over the country, and they may leave a state, close all their stores in a state, but they're in 20 other states. So it's kind of a non-event unless some of the partial rules are triggered, which we'll get to.
But were you asking about the payment of the withdrawal liability or the actual, whether there's an actual withdrawal?
Well, the payment amount, the itemized by each company, and you realize there's a brother-sister relationship there, whatever you call it, and are they going to total liability between all the companies?
Yeah, I mean, you're viewed as, they would have one line item as to who you are, and would subsume the 3 entities into one. So, so the control group works both. It's taken into account whether you've had a withdrawal, but once you've had a withdrawal, then everybody in the control group is fair game to pay it. So if you have company A, B, and C withdraws, it triggers a partial, the plan can pursue A, B, C, or some combination, or so they all.
They pay the liability of all 3 companies out?
If it's a complete
withdrawal.
If it's a complete withdrawal, you have to pay for all 3. If it's a partial withdrawal, the plan can pick who pays it. So it's.
And when you get the estimates too, if you're asking for estimates, which you have a right to ask for, the plan may or may not have identified all 3 entities in John's example as being in the controlled group. That analysis may not be done until one of the entities withdrew.
Right.
At that time, the plan might take a closer look and realize, B and C are also part of this controlled group. We just had them listed as 3 separate employers. So you shouldn't assume that, like if you were getting an estimate for A, that, I don't have any liability for B and C. The plan may be unaware that they're affiliated, that they're a controlled group. And so just, those estimates, they are estimates and they don't necessarily take into account all the facts and circumstances. And upon A's withdrawal, if there's a partial withdrawal or a complete withdrawal, only at that point will the fund necessarily take a close enough look to truly evaluate the controlled group. So
Yeah,
just a caution.
When we have a withdrawal, we send a worksheet to the employer that's gone out, and one of the questions on the worksheet is identify all of your shareholders, all your related entities, and maybe at that point, the plan learns.
Oh, come on, you stupid.
What we thought were separate employers were all one and the same. So it's, but again, it might be to your advantage that the plan views all of your entities as one and the same because it's a shield.
Right, that might result that you didn't in fact withdraw
Okay.
because you have some other operations that are in the plan.
We're still chugging along, so go away. So we're going to start with the general rule, and think about this rule for industries like retail, manufacturing, transportation, truck driving. So the big 800-pound gorilla here probably is truck driving in central states. So the general rule applies for those industries. We're going to talk in 10 minutes about the construction industry exception. So industries other than construction, the general rule applies. You'll have a complete withdrawal if 2 different occurrences arise. One would be you completely cease performing covered operations. You go out of business, you're decertified, you bargain out of the collective bargaining agreement. So, I'm sorry, that's the other one. But through no fault of your own, you stop operating under the bargaining agreement, you stop creating contributions, it's permanent, it's not a temporary shutdown like a strike. That's a withdrawal. The other is you no longer have a contractual obligation to contribute. That would be the bargaining on the decertification. So it's a pretty broad definition. Basically, you were an employer contributing to the fund one day, the next day you're gone, and there's these 2 different potential reasons why you're gone. Either you're not doing anything anymore, you sold assets, you stopped working, or you don't have a contractual obligation.
And remember, intent is not relevant. Like it's not, it doesn't matter if you didn't want to withdraw, you didn't want to stop contributing if you stopped contributing.
One thing we saw in the Teamster world, this is probably still going on, is the Teamster union reps were more than happy to negotiate you out of Central States pension fund, which is the most toxically underfunded pension fund in the country. They'd be happy to negotiate you out of that defined benefit plan into the Teamsters 401k profit sharing plan. The union was probably maybe in the union's interest because the members could see the account statements, you know, you want to be in a failing defined benefit plan member, or do you want to be in this defined contribution plan where you get assets going towards retirement? So the Teamsters would negotiate employers out, and then the butcher's bill would come due because Central States would come after the employer for complete withdrawal. So we have seen this. We've also seen some employers that have said, enough. We want to fall on our sword here. We've been putting this off. We're in a position now, cash-wise, where we're going to trigger the withdrawal because we don't see it getting better. We see it getting worse. We're going to negotiate into the defined contribution plan and stop the bleeding. So on Central States, which is its own animal, they got an in-house law firm of like 50 attorneys that do nothing but very, very rigorously pursue withdrawal liability employers. We've worked with a lot of employers over the years. They're pretty hardcore. They make most of the law. Most of the law that comes out of withdrawal liability is driven by the Teamsters, the Central States Fund. So I think that some of the good examples of how the general rule works comes from the Teamster rule. So a stock sale will not trigger a complete withdrawal because it's viewed as the same company. It's just somebody else owns the stock today. So that's business as usual. But an asset sale under the general rules will trigger withdrawal. So even if the buyer of the assets is still in the plan, contributing, operations continue, the fact that there's a different owner on Monday than there was on Friday, and assets were sold over the weekend, is a complete withdrawal to go after the seller. There is an exception. It's noted in the outline. 4204 is the ERISA section. You can structure the asset sale so that the seller is not liable. The buyer has to step in the shoes and contribute to the plan. But it's just an example where how's the plan been harmed if the assets were sold and the buyer is still in the plan? It doesn't matter. We have a different ownership group, so that can be a withdrawal. And then sometimes get into disputes as to what does a complete withdrawal mean. In the circuit we're in, they say that a complete withdrawal means the full set of operations. So years ago, I worked at the Milwaukee Brewery Workers. It's a public case. I'm not talking out of school on this. But Pabst Brewery stopped brewing beer. And Milwaukee Brewery Workers was about 50% funded. So there would have been a huge withdrawal liability assessment against Pabst. And when Pabst said, no, we haven't completely withdrawn. We've got this one guy working in the warehouse. And we're going to keep contributing on him. And we're not, we may have a partial withdrawal, but we're not going to have a complete withdrawal. In our circuit, all operations have to cease. We have this warehouse guy. We call him the $1 million man because basically that's what he was worth. There are other circuits where they say that skeleton crew or wind down. If your essential operations have ceased, that's a complete withdrawal. There's a Third Circuit case on that. So the law is a little different, but sometimes all means all, and sometimes I guess it doesn't. But my past example, we eventually were able to work it out. And I note the evade or avoid standard that we'll talk about. So we're now moving into the partial withdrawals.
We are. You're doing great, John.
So if you think about
Oh, you want me to talk for a little while? All right. So there's a couple of different partial withdrawal triggers. The one that's listed right here is the facility closing. So you can have these partial withdrawals. Again, it's not all means all, but so here if you have, say, multiple facilities and you cease contributing or having that obligation to contribute at one or more, but fewer than all of the facilities that participate in the plan. So the obligation to contribute with the employees at that facility terminates. And then importantly, you continue work at that facility. You're going to trigger a partial withdrawal. So if you think about it, sort of effectively the facility has kind of transitioned that work from covered work to non-covered work, and they're still doing work there.
But if you just shut the facility down, operations are done, that does not trigger this withdrawal. It's basically what had been contributory work, that work continues, but it's not producing a contribution. You'll be tagged for a partial withdrawal for another facility closing.
And then with sort of a similar concept, some but not all sort of like framework, if you have multiple CBAs requiring contributions. And so you cease having that obligation to contribute under one or more, but not all, CBAs under which you're required to contribute. And again, these rules are always complicated, unfortunately. You continue to perform work or transfer that work to another location, and contributions are no longer required for that continued or transferred work, then you have a partial withdrawal under this sort of some but not all CBA contribution obligation. And then the last trigger, and this is one that is pretty significant, but gets into sort of that declining obligation over time. And this rule is ridiculously complicated. You sort of need a whiteboard to map it all out. And we told Derek he didn't need to keep the whiteboard in here. But you have a 70% contribution decline. And you're measuring that over 2 plan years and comparing it back to a 5-year period. But if you think about it, you're contributing at a level of 100 CBUs, say, per year. And that's maybe been consistent historically. So over a 5-year period, it's that 100 CBU level. And then in the subsequent period, for 3 straight years, you contribute at below 30 CBUs, you're going to have a partial withdrawal under this test.
Yeah, and a CBU is a jargon term. It's a contribution base unit. So what the plans are looking at is, if you contribute by the hour, that's a contribution base unit. You know, in some industries, they'll contribute by the month or by the week or by the shingle laid if it's piecework. I mean, it's what generates the contribution to the plan. I think most of our CBAs are the hourly. The contributions come in. So the CBU there is easy to get your mind around because it's an hour. Sometimes we have employers who'll have one CBA that's based on shifts and then another CBA based on hours, and we got to kind of figure out what the CBA is, CBU is.
We've had some groups where they're contributing on a monthly basis, and so they've got participants where it's monthly, participants where it's hourly, and you have to try and find some way to make all of that make sense and put it all together. But for the majority of the people, presumably on this call or here, it's going to be basically looking at hours. You know, how many hours were you contributing for?
And so the last slide before we delve into the construction industry exception is the evade or avoid standard, which it's intended to prevent employers from engaging in transactions where a principal purpose of the transaction is to evade or avoid withdrawal liability. If there's a good business reason for what you did, then the evade or avoid shouldn't be triggered. But a great example of the evade or avoid standard was a super value. It was in a Teamsters plant in Pennsylvania, and they were looking ahead, and they saw that if they withdrew in the current year, their liability would be less if they withdrew in the following year. Unfortunately, the bargaining agreement required them to stay in the plan into that next year, but they knew that their liabilities were going up. So what Super Value did is they negotiated with Teamsters to get out of the plan early to again, throw themselves on their sword. They wanted to withdraw in 2020 because 2021 looked awful. So they negotiate out of the plan in 2020. They take a withdrawal. The union also extracts some value because they had to open their contract up. And then the plan sues Super Value and says, no, the only purpose for entering into that bargaining agreement acceleration was to evade or avoid withdrawal liability. And the court said, yes, there was no other business reason for doing what they did. It wasn't just a principal, it was the principal reason for opening the contract. And the court said that transaction was evade or avoid, so we're going to ignore it. So your withdrawal is deemed to have occurred in the following year as if you had negotiated out, and all those concessions that the union negotiated in exchange for letting you out, they get to keep. So that's kind of a classic example of evade or avoid. My Pabst Brewery situation was another one. And this warehouse was full of moldering, shelf display stuff. There was no reason to have a warehouse after they shut up operations here, except to avoid withdrawal liability. I think if sometimes it's a partial withdrawal. Bill gave the example of 5 years at 100, then you get 3 years at 29. That's a partial. Well, if you have 5 years at 100 and then organically you're 29, but you put a bunch of guys on the last week of the third year to go from 29 to 31, as long as you get over 30 for one of those years, if you didn't actually have work going on, that could be an evade or avoid. So this is, I think withdrawal liability is on the table, so it's hard to say it's not a principal purpose for making decisions, but it has to be, you have to come up with some other business reasons as to why you're doing something. So super value opened the contract early because they had some other business reason, not just to skip out on some higher withdrawal liability. So
It's worth pointing to, it's a principal purpose. It doesn't have to be the only principal purpose for the transaction. Obviously, if it's the principal purpose, you've got a problem. It's sort of a huge smoking gun that's sitting there. The other thing is that it's important. It's not that withdrawal liability can't be a consideration for the, I mean, it's okay if that is part of the discussion. It just can't be a principal purpose. And that's so, because oftentimes that will at least be discussed. But we'll also see a lot of issues surrounding like documentation, like, you know, the email where somebody says like, well, whatever happens, we have to avoid paying withdrawal liability. You know, that's like the smoking gun that Derek would be looking for in that. He's making the money sink.
okay, so those are the general rules. Are there any questions about the general rules? They're pretty broad, pretty easy to trigger a withdrawal if you have a pull out of your contribution obligation. So in law school, we spend the first year learning about contracts. In the first semester of second year, we learn about bankruptcy, and the professor said, all that stuff you learned for the first year, we're ripping it all up. And that's kind of what the building and construction exception provides for. So all the stuff you learn about under the general rule, there's a huge exception.
But it's an if. It's if you meet it. You know,
Right.
It's a huge exception if you can meet it.
We don't, and one thing we want, if you're in a laborer's fund or a mason's fund or a carpenter's fund, sheet metal, whatever, just keep in mind, just because it kind of walks and talks like it's building trades doesn't necessarily mean you're going to pass the test. So there's some definitions here we're going to get into that I think are fairly important. So the building and construction industry rule works if both the employer and the plan qualify under the definition of building and construction industry. Go to the next slide. I helpfully point out
Another nice, simple, easy rule to apply here. See, it's 10 lines long.
okay, so if you're a building and construction industry employer, your plan's a building and construction industry plan, then you're only going to experience a complete withdrawal if your obligation to contribute ceases, i.e. you bargain out of your contract. So you no longer have a contractual obligation to contribute, and you continue performing in the bargaining agreement's jurisdiction on a non-contributory basis, or you resume those operations within 5 years of the date your contribution obligation ceases. So if you bargain out and you want to go to a beach in Florida and never work with the tools or hire anybody to work with the tools again, that is not going to be a withdrawal. If you sell the assets to somebody and you and your family members completely stop working with the tools or in the industry, that's not a withdrawal. So obviously this is a lot different than the general rules where both of those actions would have been complete withdrawals. So 5-year period after the contract obligation ceases. I want to point out that the reason for the rule was when Congress adopted this exception in 1980, the thought was in the building trades, a lot of the work is done through bidding. And the fact that you may go on a cold streak and not be getting bids doesn't mean the plan's been harmed because other signatory contractors are getting that work. So their view is contractors are kind of fungible. The fact that you got work on these projects but didn't get one on this project, plan's not hurt because some other signatory firm got the work on this other project. And the other reason for the exception is there are a lot of national contractors that will come in on a project basis, do a project for a year or whatever, and then exit the jurisdiction of the bargaining agreement. That's not a withdrawal because they've left the bargaining agreement's jurisdiction. So that's what the statute's trying to get at here. That's why you have this exception, is that you may no longer be in the frame, but other employers who are signatory are around and are contributing to the plan's not harmed.
Mike.
Yeah, presumably the work is still there. Oh, sorry. Presumably the work is still there. It's just being done by other contractors. So there's no real reason to assess against you.
Okay, very good. Appreciate it. Thanks, Mike.
Okay, so we've laid out this great exception. Unfortunately, we don't have a definition of what building and construction means. We've kind of pieced one together from a lot of other different federal laws that define building and construction. And the last bullet here kind of distills or synthesizes what those are. It's work or significant work on a job site. So construction, reconstruction, repair work, or renovation work. So basically, if your employees are on a job site, that should be building and construction work. Turning to the next slide, things that aren't building and construction, manufacturing. So like some manufacturers will assemble things that are then installed on a job site. The manufacturing by itself is not building and construction work. Delivery, this often creates questions. Well, we delivered the materials to the work site, but we didn't install them. The delivery function by itself is not going to be building or construction work, or service or maintenance work. Some of the trades, signatory contractors will be primarily maintenance or service. That's not job site building and construction, at least under the definitions. I had a case, it was a close call. There was a company that they do scaffolding. They come on site, they put the scaffolding up, project's done, they take the scaffolding down. There's some aspects of the law that suggested the construction work had to be permanent, but the NLRA viewed scaffolding work as construction trade, so we were able to get comfortable there. So, but think about people wearing hard hats, using their skills on a job site.
But oftentimes we've seen also employers will have people doing actual on-site construction work, but they may also have a shop that's doing work, or they may have a delivery operation or something like that. And so distinguishing between those can be challenging too. And there's a slide coming up, I think, talks about the percentage.
Might be the next one. The law says that substantially all of the employees have to be in the construction industry. The law doesn't define substantially all, but it generally means 85%. So to Bill's point, like in the UBC world, there are some signatory employers, all they do is mill or they make doors or railings, but they don't install it. So even though they're in the universe of the building and construction world, 85% of their employees are not on job sites. Instead, they're doing work that's more manufacturing. So there certainly are within the building trades unions some contractors who potentially are not construction contractors. So they are not eligible for this rule. The next requirement is that the plan also be a building and construction industry plan, which means at least half of the CB contribution base units coming in are on behalf of construction work, or the trustees can preempt it and say, we're going to amend the plan and say we're a construction industry plan. So you need two to tango. The employer has to be a construction industry employer. The plan has to be a construction industry fund. We are sometimes asked, an employer is going to sell its assets or cease operating. They'll contact the plan and say, can you tell us whether or not the exception applies? And generally, as an attorney for the fund, I can say, yeah, the plan is a building and construction industry fund. We've either amended the plan or trustees have looked at where the contributions come from, and more than half are coming from construction work. But whether you are is something in facts and circumstances that's going to be determined by what you do.
Yeah, the risk there is just assuming. You know, if you just assume, well, I'm in the construction industry and therefore I have the benefit of this exception, that's a little bit of a risk. It may be very obvious, you know, your operation, but there's at least some risk out there that if you make that assumption, you might be in for a rude surprise.
So that's the complete withdrawal exception for, basically you're operating, if the exception applies, you're still in the jurisdiction of the CBA, the bargaining agreement, and you're not making contributions to the plan. So we have some case studies that we hope kind of flesh out some of the differences in how the rules work. So
I'll read them, John, and you can opine on them. The owner of a construction industry employer decides to retire, completely ceases operations in the industry. The employer notifies the union it's terminating its collective bargaining agreement. If it qualifies for the construction industry exception, not a problem.
It's a non-event. On the other hand, if it's United Food and Commercial Workers, Unite Here, Teamsters work, that's a complete withdrawal. And they'll find you on your beach in Florida and serve you with papers to appear for a collection action. So I think the first example drives home. If you completely pull up stakes, and a lot of baby boomers now are their companies. They've come to their life end, and they just want to get out of the business. But they were building and construction industry employers, and the plan's building and construction industry. They can pull up stakes and disappear, and it's not a withdrawal event. Whereas if you're a trucking operation or you operated a fab shop, that will probably trigger a withdrawal.
The second sort of simple example, employer stops participating in a multi-employer pension plan after it sells its business in a stock sale. The liability goes with the business. It's been sold in a stock sale and is assumed by the buyer. And so the seller is most likely off to the beach.
Right, and we often get fund offices will call us and say, hey, so-and-so just sold their business. My first question was it an asset sale or a stock sale? They've got to go back and look. Because if it's a stock sale, it's a non-event under the general rule or the construction exception. Now, if you are selling your stock, the valuation for the stock, if it's if there's a withdrawal liability exposure in there, that obviously can impact the valuation of the stock. If the appraiser for the company is half awake and they realize that this is the stock sale involving an employer in the Central States, the value of the company is going to have to reflect that contingent liability.
So the next case, the national construction firm ceases performing projects in the local union's jurisdiction. They terminate the collective bargaining agreement, but 3 years later, they come back into the jurisdiction as a non-signatory business performing covered operations in that jurisdiction. In that case, you will not qualify for the construction industry exception.
Yeah, so that's a classic example of you're dormant for 3 years. Maybe you start a new business that comes back, or you shut down your business. 3 years later, you get the itch to come back and start bidding on jobs again, but you don't do it signatory. But it's the same ownership group. Another example, this was a recent case, big national company. They bought a firm in the jurisdiction that they used to work in. The firm they bought was non-signatory. The fact that they purchased a company, much like if they started a company, was enough to trigger a complete withdrawal. So there's either you continue operating non-signatory, or within 5 years of your bargaining agreement terminating, you resume operations and you don't have a contribution obligation.
Yeah, I mean, I remember years ago talking to somebody who was thinking like, well, we'll sell that business and then we're going to start up a non-union business. And I'm like, well, that's not going to work, at least not anytime soon. So
if you wait 6 years and you're 5 years in a day, in theory, it would work.
the next example is the sole shareholder of the employer ceases operations, retires. He sells the equipment to his family members who operate as a non-signatory employee in the same location, same employees, same customers.
So this goes to the successor example we talked about. Generally, in an asset sale, the buyer does not pick up any of the seller's obligations. But in this example, you're selling to a family member. They knew about the fact that there was this pension fund out there. So we would take the position that the buyers of the assets are a successor. Now, this is relevant for the construction industry. I've got a live case in Indiana right now. It's again publicly filed, so I can reveal information about it. It was a 7th generation carpenter construction firm, union, in a defined benefit plan, and the owners wanted to retire, so they shut down the company, terminated their bargaining agreement. Well, they sold the assets to their nephews and other family members who moved in the same building, hired the same employees, worked with the same customers, non-union. So the first position of the signatory entity was, we've ceased operations. We're not operating anymore, and we have to continue operating non-signatory. We're not doing that. We're out of the business. But our position is, no, this shadow group that came in and took over operations is you. You're one and the same. The fact that they're operating within 5 years, you've triggered a withdrawal. Now, the company that stopped operating didn't have any assets, but those purchasers do. So this is an example, covers a couple of things. First, how the construction industry rules work. You have to be non-signatory. Like, well, how can we be non-signatory? Well, if you sell assets to an entity that doesn't continue contributing, potentially that could be viewed as a successor. We don't have a decision yet on whether that works, but the successor would certainly be liable for anything the employer would have owed. But the employer's position here is, so we sold our assets, we stopped operating. That is not a withdrawal. We have to resume operations. We're never going to do that. They're long gone. But these family members were, with the law change in 2016, we've taken a position, and we'll see if it delivers.
So the next, the control group that own 3 construction firms, we talked briefly about the sort of ABC example.
Yep, this is exactly what you talked about, and it kind of leads in a little bit to the partial rule we'll talk about. But as long as some member of the control group still in the plan, and the plan realizes you're all part of the same corporate family, that employer hasn't effected a complete withdrawal. Oh, that's the bottom one. The top one is actually an interesting case. And I don't know if I've got this. Yeah, I've got this going on now in Indiana as well. There's a signatory entity. They're signatory with the roofers, and the members are getting fed up with the roofers. So they want to decertify the roofers and become recognized by the carpenters. And so that under labor law, that can happen. You can take off your roofer's hat, put on your carpenter's hat. But in the switches, the employer is going to go from contributing to the roofer's defined benefit pension plan to the carpenter's defined benefit pension plan. Well, that's a withdrawal under the construction rules because they're still operating in the same jurisdiction as the roofer's bargaining agreement, but they're not contributing to the roofer's plan anymore. And the law doesn't care that we're still contributing to a defined benefit plan. It's a carpenter's plan, it's not the roofer's plan. So
That's like the intent, like they don't care about the intent. They also, the fact that, well, I'm still a union shop, I'm still contributing on behalf of members to a defined benefit plan. That's not relevant to the analysis. You were contributing to the roofers, now you're contributing to the carpenters. You're still doing the same work in the jurisdiction of the roofers.
it's one of those spots where the roofers and the carpenters claim jurisdiction over the same work. So if it had been work that would not have fallen under the roofer's bargaining agreement, then it would not have triggered a withdrawal. But it's the type of work that they both claim. So you're going to have a situation where the roofer's pension fund potentially could go after them for staying in the jurisdiction of your old bargaining agreement, doing covered work, but not paying the roofer's fund. So it's.
And this is also, I've seen this also come up in the manufacturing or shop context where people change, they decertify and they go to a different union. Or even in, sometimes the office staff are organized, and you'll see an office staff, they'll have a change in bargaining representative. Now they're contributing to a different plan.
One thing I thought about it after I published the slides, and it's just kind of a footnote out there, is we'll run into subcontracting situations. The general contractor might self-perform work, and then at some point it stops self-performing, and then instead hires a subcontractor to perform the work. As long as the general still has a contribution obligation and the sub is contributing to the fund, it's a non-event. Where it gets a little dicey is if the general contractor self-performs and then terminates its bargaining agreement. It's going to stop doing any self-perform any work. It's going to, going forward, have subs do all the work that it used to do. There's some instances where, well, if that sub isn't contributing to the fund, we're going to impute that to you. And some courts have said, yeah, that triggers a withdrawal. The fact that you're not operating anymore doesn't matter. The subcontractor doing the work that you would have performed is sufficient to trigger a withdrawal. On the other hand, if the subs are still in the fund, then in theory you should get a pass. But I didn't put a slide on it, but it's something that we have run into, especially for any general contractors who might be in the fold and who have self-performed. You potentially could have a tripwire on that. So again, getting back to your example, you've got 3 corporate entities. One drops out of the plan, the other 2 are in. It's a perfect segue into the partial withdrawal. Now, Bill talked about there were 3 partial withdrawals in the general rule: facility closing, bargaining out, 70% decline. There's only one rule for the construction industry partials, and it's kind of a fuzzy. You continue your obligation to plan for no more than an insubstantial portion of your covered work, which doesn't really mean anything because it's not defined. I think the next slide is helpful. This partial rule really is intended to apply to double-breasted situations where you have a union shop and a non-union shop in the same jurisdiction. And over time, you start moving some of your union work to the non-union work. So we're going to look at all the covered work you're performing, and if no more than the insubstantial portion is being contributed for because you've moved from 60% contributory to 20%, and you've moved what had been contributory over to the non-union side, that's going to be a partial. But you can have a 70% decline, and the plan won't care. That's not if you're bidding and not getting the work, and your contributions go down 70, 80%, and that's all you do, that's not a partial. It's only a partial if you have some other operations that are getting work, but you're not paying for it. So we rarely see building trade partials, although we've got one going right now, but it's pretty rare. I wanted to make a point earlier too. I've got 7 building trade defined benefit plans. We have 1 active case. I've got 1 general rule plan where they've got 53 withdrawal liability cases. So these withdrawal cases in the construction industry world are very rare. In the general, under the general rule, they're pretty common because most plans are are underfunded for withdrawal liability, and some, like central states, to the point where they'll never recover.
So the next piece is, so how do you calculate the actual liability? At the beginning, when we were talking about the takeaways, talked about there's the withdrawal liability, so they assess you, I think John gave the example a little while ago, $5 million. But what do you actually owe? How does this work? First of all, there's different withdrawal liability methods. We're not going to talk about those in any great detail, but the presumptive method, which construction industry plans have to use, looks at a 20-year history of the plan's experience to figure out what the withdrawal liability is. It amortizes the sort of basically charges and credits over that time. It's very complicated, but the bottom line is that they're going to have to use this methodology. It's incredibly difficult if you have to try and figure out, and you get assessed and you're trying to understand how they calculated the withdrawal liability. John also gave the example earlier of, say, another employer went bankrupt and left the fund sort of in the lurch. That amount then gets reallocated to everybody else. That's part of the calculation of the withdrawal liability.
So real simple example, we assumed that we were going to get 7% return in 2018. We had negative 3%. So there was a loss that year. Let's say the plan had a $500 million loss. So that $500 million loss is allocated among all the employers in the plan based on their fraction. And the fraction is an employer's contributions for the 5 years before. That's the numerator. And the denominator are all the employer contributions. So the bigger you are in the fund, the bigger the share you're going to get of that underfunding for the year. And as Bill said, it's amortized over 20 years. So you create this really big pool in 2018. 95% of it's still around 2019. 5% a year, it goes down. After 20 years, it's gone. But that's kind of fractionally how they determine what your share is. So you're looking at, there's a 25-year tail right now. So you've got liability from 20 years ago.
Right, the tech
bubble.
And then that some of you will remember, that's still in there.
And then it was 5 years of contributions before the 20th year. So this is a pretty complicated. Last year was a huge gain because I haven't seen the final numbers for calendar year 2019 yet, but we were well over 7%. Bonds were close to double digits, and the S&P was mid 20%. There was a gain, and that gain will also be allocated fractionally to the employers based on the relative size of their contributions. And then so these gains and losses are in the system, and they offset each other, and that's, I'm a journalism major, that's as much about actual science as I'm going to get into. But
so then there's the calculation of the actual payments. As John said, it's simple. Once that $5 million that might be owed isn't payable right away. And so of course they came up with a nice complicated formula for calculating payments themselves. So that's, they're looking at your highest contribution rate during the year of the withdrawal and the 9 preceding plan years. So typically contribution rates are increasing, but they're looking at the highest contribution rate. Then they're also looking at the high years for which you were contributing. So if hours were higher at some point. So they're kind of trying to laser in on, when you were at your peak in terms of contribution volume, what were you contributing to the plan? And so they take, sorry, go ahead.
Like I said, it's going to bear some resemblance to what you paid for contributions, but it's amped up.
Right. So they're looking for like the high water mark, effectively. And then they're going to take that, and that's going to become the annual payment that you would have to make. And withdrawal liability is generally capped at 20 years. It's payable quarterly. So there are some variations. I think Central States, it's monthly, isn't it?
Yeah.
So you can apply to the PBGC for a change, but for most employers, you've got this 20-year cap. You're going to contribute 80 installments if you hit the 20-year cap. And there are employers, I saw an assessment over the weekend for somebody who was hitting the 20-year cap. And so if you think about it, the $5 million assessment, if you look at the present value of the payments over 20 years, it may be far less than $5 million.
Right. I think it's important, if the assessment's $5 million, the payment schedule is not intended to capture the $5 million. The payment schedule is completely different than the factors that went into determining the ultimate amount of liability. Those are done on actuarial differences and shortfalls. Your payment amount's going to be based on your contribution history. So that, again, it's that sticker shock on $20 million of withdrawal liability. Well, you do your payment schedule, and maybe that you owe just a very, very small fraction of it because we stop making payments after 20 years in the normal course.
And you're entitled to make a lump sum payment, and in fact, many funds will accommodate and welcome a lump sum payment of any withdrawal liability, because it's sort of the bird in the hand versus waiting, hoping the employer is going to be around for 10 or 15 or 20 years to actually make those payments.
Yeah, I don't have to chase employers for 20 years. If you come and make a present value calculation, plans will play ball, but it takes obviously money. Are we at the end?
We are.
Wow.
Although there was a question, but go ahead. You want to give your conclusions and takeaways?
Sure. So the takeaways would be the construction industry versus the general rule. Figure out if you're in multi-employer plans, figure out whether your operations are 85% construction site versus something else, and then confirm that the plans are also building trades plans. Identify who's in your corporate family. If you're diluted and spread out, try to get a handle on ones that may be within or without. Certainly identify any unincorporated trades or businesses. This is, again, employers withdraw. They're withdrawing because they're in bankruptcy or they just can't make a go of it. They have no assets. So the plan will say, okay, we're going to write off what the signatory entity owed. And now we're going to start looking for family members and what they owed, or other corporations, family members, again, incorporate anything that would be considered a trade or business. One item here under the things you can do to get your mind around withdrawal liability, you can request an estimate. Now, if you were to request an estimate today from a plan, it would be based on a withdrawal in 2019, which is based on the 2018 unfunded liability. So you're always, the estimate you're going to get, and the plan can take 6 months to give it to you and charge you, but the estimate you get in 2020 is based on old news. It's based on the plan's 2018 funded position. And one thing I wanted to note here too, and Bob, maybe you've got some insights. The PPA, the Pension Protection Act, requires plans to identify how well funded they are for minimum funding purposes. And that's kind of the actuary figures out what the plan's funding percentage is. But for withdrawal liability, you can use a different set of numbers. And it's been known as the Siegel blend. And the Siegel blend method can take a 100% green zone plan and create billions of dollars of liability. So the plans I work with in the AGC world, the same assumptions we use for funding, we use for withdrawal liability, but some plans will use a completely different set of factors. So you may think this is a green zone plan, we're 100% funded, we get our annual funding notice from the plan under PPA, so the plan's in great shape. But the law, there are two courts that go different ways on it. Potentially some plans can use a different set of numbers and factors. They use a much lower discount rate to really jack up the liability. So that's another reason why, I guess, not just relying on your PPA annual statement to maybe consider an estimate.
Well, and if you've got a plan that is in real distress, you may end up having much higher withdrawal liability as a result of that. Plans that are terminating use different factors. So there's, if you want an estimate, I think some funds will charge for that. Some will charge just a nominal fee, but I know in a number of discussions with boards about whether they want to charge for those estimates, a lot of the trustees recognize that contractors want that information and they don't want to make it so expensive that contractors can't at least get some sense of what their withdrawal liability would be, so that the charge would be, in a lot of cases, pretty nominal.
Plans don't have to give you the payment schedule. They just have to give you the sticker shock number. The payment schedule, though, is within the documents you have provided you've got 10 years of contribution history. So I would encourage you to retain your contribution history, because if you were to withdraw, you're relying on the plan office's numbers, and it might be, plan offices make mistakes, as we know. So if you do have your own records, keep them. Sometimes records are shredded after 7 years because the IRS is a 6-year and then you got a year on. Withdrawal liability, actually, it's 25 years of contribution history, but at a minimum, keeping 10 years makes sense. So we reviewed the law today. I don't know anybody who's been reading on some of the press on pension funding, or the trustees, anybody here who's a pension trustee. There are proposals to kind of bail out underfunded plans. There was a loan proposal that the Democrats came up with. And the Republicans in late November came up with their proposal, which involve increasing PBGC premiums, surcharging unions, employers, and retirees, kind of trying to fund the plans, not using the Treasury Department to fund. And one item in the proposal was a change in the withdrawal liability rules on the installment payment side to look back at 20 years of contribution history, pick the high year, high rate. So there could be a change in the withdrawal liability rules. I mean, it's like you just take body blow after body blow, and then you get to the end of the proposals, and there's this proposal to make withdrawal liability worse by increasing all the installment payments. This is just a proposal from Senator Grassley and a couple other Republicans. I don't think it's been teed up as a law yet, but law changes. Some of the withdrawal liability rules changed with the PPA and surcharges and whether those are counted or not. So
There's a lot of indirect impacts too from some of these law changes, which may not directly impact the calculation of the withdrawal liability or the payment schedule or when a withdrawal occurs, but even if they change sort of the funding rules, and all of a sudden you're getting statements now that show that your plan is that you're participating as green, it might show that all of a sudden your plan is in distress if they change. For instance, they're talking about changing the assumed rate of return to 6% instead of 7%. Well, if you do that, you could have liabilities go up by hundreds of millions or billions of dollars depending on the size of your fund.
yeah, and then employers will start looking at, well, we have to get out of this fund, because that is one of the proposals is to use the bond rate as the present value. So you're not using 7%, you're using 4 or 5%. On the other hand, there's some hybrid plan options that won't have withdrawal liability that are part of the bill that might attract employers to come in. So there's a lot of plan design opportunities as well, where going forward, maybe things are rosier, but you still have whatever you have today has to be funded. So there's only so much you can do with that.
One question that I think Derek or Barry forwarded to us just briefly was the likelihood that the accounting firms will be requiring you to disclose withdrawal liability on your financial statements. That was a proposal from that came out maybe 10 years ago now, and was met with a pretty strong pushback by unions, by employer groups, by advocacy groups, people who understood that this is go back to the whole meat of this discussion, it's a contingent liability. It's not a liability that definitively exists today, and there was a lot of education that occurred as part of that. But that possibility exists. The likelihood that it happens, I haven't heard any real rumbling that they're going to push for it again. I don't know if you've heard anything, but it certainly could happen as a footnote. But one of the big reasons to not feel like you should disclose it is it makes it look like on your financial statements you have this gigantic liability, which is truly only a liability if A, B, C, D, E all happen, as we've sort of walked through in this presentation, and it's not actually a liability today.
Yeah, the compromise, the proposal was you'd have to more or less show on your balance sheet the estimated withdrawal liability. The compromise is you have to footnote multi-employer defined benefit pension plans you participate in, their zone status. So you have to provide in a footnote some information about, so somebody could look at the footnotes and say, well, I got some follow-up questions about these plans that are footnoted, but that was, and I think the association has really locked arms and pushed FASB on this to point out all the ways that having to include these estimates on the contingent liability made no sense. So that hopefully is something they won't revisit, because there were pitchforks and torches last time.
I think we went probably way over the time that you had allotted for this. But if there are any questions, happy to try and answer them.
And what percentage of the fund really in trouble that we need to be concerned as employers?
It's a lot of different levers. So, I think everybody focuses on the funded percentage. And if you look at the PPA zones, sort of obviously 100% is what everybody wants to be at. 80%, when you go below 80%, then you're outside of the green zone. And that's a good metric to look at. It'll give you some insight. Below 80, you're in yellow or potentially going into red. There are other things that can trip you into red or yellow, or that can keep you green. But a lot of it is sort of the health of the industry. I've got one fund that I work with, they're 100% funded, and they're in the red zone because their contribution base has shrunk so much. So they're just bleeding cash at this point. Their entire income, all their revenue is investment returns. And so that's not a healthy fund. But if you looked at the funded percentage, you'd say, this is great. I'm in a 100% funded plan. And in fact, a buyer of a company that participated in that plan has pointed that out to me a number of times. I mean, I didn't have anything to do with it, but he was rightly frustrated that he ended up coming into a fund that's 100% funded and looks great if you don't look below the surface. And in fact, that fund is destined for insolvency because there's just no contribution base left.
I mean, employers can, in addition to requesting estimates, you can request copies of the actual evaluation and the financials. Those have to be produced within 30 days. So those will give you some insights too. And there are the bottom line numbers, but then there's some of the details that, again, your accountant could work through, or even you. I mean, the trustees, we're not actuaries. We can read through them and kind of get a sense for where things are. But I think, yeah, the industry is pretty important. I mean, it's the hours we've seen have been on for the building trades in Wisconsin have been in pretty good shape. That goes a long way because you're getting $10 an hour for all those hours, and there's margin in there. We're not just buying new accruals with the contributions that come in. We're paying down some debt because the PPA required us to do things to get the plan healthy. So if you went through a red zone or yellow zone plan, you had to do some things to get yourself better. The game that we're fighting now is so much of what's going on is legacy debt, and we're really levered. We have all these liabilities, we have all these assets, which is great, but we really need our assets to get 7%. And if the markets turn for a couple of years, it doesn't matter how many contributions you make. Contributions are so small relative to what the investment returns are as you get a mature plan. So but that's just how the industry works. I mean, eventually all these retirees are going to have to be paid.
And John mentioning a mature plan, on a cash flow basis from a contributions versus pension payments, as these plans have become more mature, you could look at the cash flow and say, this plan looks terrible. That, contributions are X and pension payments are much higher. But again, the asset base and the investment returns that they're projecting more than cover that liability, and they could be in great shape, and even with a conservative investment return, be completely healthy. But you might look at that and say, boy, they're only getting so much money in terms of contributions annually, and they're paying out this much. This is a really bad situation, but it might be in fact a very healthy plan.
Yeah. But you'd sure like your cash flow to equal your benefit, your payments.
In a perfect world.
For those years when the stock market's down and you don't want to sell your stocks at the bottom and make your monthly benefit payments. And we do, and we are seeing there are a lot of plans in Wisconsin where because the hours are good, we are keeping up with cash flow, or the bonds are, the coupon is the dollars there that you can capture. You don't have to sell any assets, but we're going to get cash.
Yes.
I've read a couple of different areas about central states not being in place after 2025. Do those numbers sound right to you, or are they still trying to hit a moving target?
That's still the year. That's also the year the PBGC
goes insolvent. Yeah.
So both bills that are, well, one's a bill, one's a proposal, earmark central states. I think central states is one of a couple of funds under the Republican proposal where potentially there could be some bailout. So we'll see. The Democratic version, there'd be a loan that would cover benefit payments so that the assets in the trust could be invested and get healthy. Eventually, even with that, it's going to fail, but it kind of kicks the can down the road a little bit. So central states is going to be, I think, really what brings us to a head, and they can only ignore it for 4 more years, and then because those participants they're in Ohio, they're in Pennsylvania, they're in Wisconsin, they're in battleground states. And it's going to become pretty headline news, type items if these Teamsters who work their whole careers are not just getting the PBGC minimum, which is small, they're getting nothing because PBGC has no assets. So something will have to be done. It's getting too close to the end.
Yeah, I mean, there will be the headline risk for everybody, politicians, as it gets closer to that date, will be severe because you have communities that are going to be devastated by the reduction in the pension payments going to those retirees. And as that sort of dawns on people, you probably see some more attention paid to how we can help out the actual pensioners. Maybe that will become the focus instead of the fund or something.
And we really don't like the fact that the building trades funds are pretty healthy and the Republican proposal hits the healthy funds. And they bail out the sick funds. And that's a concern, is that all of a sudden you kind of kneecap funds. And you know, we have challenges in the building trades. But if you make us value our liabilities at 5% and we have to pay a $300 a year PBGC premium, it's $30 now. It gets pretty expensive because like some of the actual law firms have done the math on what your premium is going to equal. And it's, you know, first 2 or 3 months of your contributions, you're going to pay premium. So that doesn't seem like a good solution either. But somewhere there's got to be a compromise.
Anything else for anybody online? Well, apologies for going a little bit long. I know it's a riveting topic, but it's obviously relevant. And, you know, through Bob and Derek, and, you know, we get questions sort of routinely, and happy to try and answer questions that may come up in the future. So thanks for your time today.
Thank you.
Didn't